So, Andrew, these jury instructions, there's 55 pages of them. I mean, we've talked about this, you and I, offline a lot. Is there a disadvantage to the fact that these jurors don't actually have their hands on these jury instructions, or does it actually, there's a school of thought that I was thinking about myself, maybe it actually helps the prosecution that the jurors don't have these jury instructions because there is some complexity to the legal concepts that are here.
You know, in the federal system, it's left very much to each judge to decide whether they want to send a written copy back or not. And I know some judges who do, some judges who don't do that. And I think it's because there's sort of upsides and downsides because, yes, you definitely want them to understand the law, but, you know, this isn't sort of a biblical exegesis where you want them to get hung up on certain words and to obsess over that, as opposed to understanding, you know, what are the legal parameters, but then really digging into the facts. And so I think, you know, again, there are upsides and downsides. In New York, they're simply not allowed to send that back, as I understand it. And so that's why the judge will reread certain portions. And that's very common. We are officially now in the tea leaf part of the, this case, which is we're all going to be looking at each note, trying to figure out what's going on. There's no question, I agree with Adam, that this is a good note in terms of assessing the jury. It's a good note if you're the prosecutors, but we're still a long way away. But I do think the big picture is kind of the one that you said, Katie, which is if you start with Donald Trump denigrating the process, all three of us do not know what's going to happen, but all three of us who've been in the courtroom day in and day out, we know to our core that this is a fundamentally fair process with good lawyers on both sides and an eminent judge presiding over it. So, you know, that I think is the real take-home message for no matter what happens in the case. It has really been handled superbly.
So, Adam, there is something that you just mentioned a couple of minutes ago. It's the unlawful means definition. And I'm actually thinking if I'm the prosecution, I would want the jury to actually have this specific definition, because if you look at it, it says that there is no requirement for the jury to unanimously find or agree upon the unlawful means by which Donald Trump was able to corruptly, reach the felony that they have in this case. And that gives the jury the opportunity to consider three different ultimate, ways by which this happened, or a myriad of ways that this happened. So is there enough clarity, though, do you think, going into the jury deliberations today after those very long closings yesterday, which I thought were effective, but they definitely were long? Do you think there's enough clarity for this jury?
I think there is going to be clarity because this jury is seeking it. They are asking for the instructions, and specifically this instruction, yes. Unlawful means. Now, if they aren't clear about this, I would expect they're going to ask for more instructions. This is an instruction that took on a life of its own. After it became public today, a lot of commentators kind of took it out of context and made it sound like the judge was turning the concept of jury unanimity on its head. But that's not what this does. And it's a really interesting moment because last week, no person other than Trump's own attorney, Emil Bove, had said that this was a usual instruction. I actually brought the transcript from last week because it's really a very interesting moment. He said, we submit, and he was arguing to get a departure from the instruction. He asks the judge, we submit that the jury should be required to make a very specific finding, as specific as Your Honor's discretion would permit. So it's very clear what happened at trial. The judge asked him, do you agree that's not ordinarily required? Emil Bove replies, certainly. And at that moment, he makes a concession. This is how it happens. Under this election law conspiracy, the jury has the discretion to decide which were the unlawful means. And in this case, there's a wide variety out there. The falsifying business records, this is one kind of choose your own adventure for the jury. The jury can decide that all those shell companies that Michael Cohen created after calling Donald Trump and going into First Republic Bank, that those bank records for those shell companies contained lies as attested to by a witness. They could find that federal election law was violated. They could find that the 1099s for the tax authorities were misleading. And if that is too many options for the jury, that's the nature of the case. That is the widespread nature of the concealment that went into the disguising of this hush money.
You know, Andrew, that's a buffet of criminality that Adam has just offered up to us. But I do think one thing that's been a critical part that we heard through the closings and also that we're seeing woven throughout the jury instructions is this issue of witness credibility. And what was remarkable to me and something that stood out to me during these jury instructions was that accomplice as a matter of law jury instruction that was tailor-made for Michael Cohen's testimony, stating that in New York, you cannot convict a defendant based solely on the testimony of an accomplice. You have to have some corroborating evidence, which is why that first note that came out from the jury, I'm really stuck on the fact that they were asking for David Pecker's testimony, not only concerning that 2015 Trump Tower meeting where I call that the original sin, where they agreed to the catch and kill scheme with the National Enquirer, and that kind of set the table for the buffet of criminality that Adam talks about that ended up happening over the next few years. But they also sought information about why the National Enquirer would not sell the life rights of Karen McDougal, why they ripped up that agreement despite having reached a written agreement to be able to do so. I mean, a lot of this seems to me, Andrew, that David Pecker, friend and mentor of Donald Trump, is the person who will corroborate very squarely what Michael Cohen said was the original conspiracy.
I couldn't agree with you more. I think it's useful for everyone to go back and think about how we were reporting on this case when we heard David Pecker's testimony, that everyone was sort of taken aback because they went, oh, this is so solid. Here you have a witness independent of Michael Cohen saying that there was an agreement that he had as a principal with Donald Trump as a principal. Michael Cohen was a staffer who was going to carry out the instructions of that agreement. And maybe even more surprising is that Donald Trump's counsel didn't really cross-examine David Pecker in terms of his credibility. So you're left with this kind of jury note saying, tell us about more. We want to be reminded about what David Pecker specifically said. He was the first witness, so this is many weeks ago. But it was very much a little bit like Hope Hicks' testimony, which was also damaging, which is also something that Donald Trump's counsel didn't really challenge. And then finally, just to your law point, New York has this rule, which is that you do have to have corroboration of an accomplice. You cannot be convicted solely, the key word here is solely, on an accomplice's word. I will say that de facto, that is really the federal system as well. Even though in the federal system, we don't have that rule. De facto, you do have that rule. No one would dream of presenting a case to a jury where the only witness was somebody like Michael Cohen, who is an accomplice. You always would have some sort of corroboration, usually very strong corroboration. But I completely agree with you. The note, well, it's just tea leaf reading and it's a first sign. There's no question that if you're the prosecutor, you think this is a good note. It is going to the heart of the case. It is going to a clear piece of evidence that was not challenged. And it also did ask for some testimony from Michael Cohen, which suggests that they didn't write off his testimony as the defense asked them to do.
This is a reminder that Donald Trump was scheduled to go to trial on federal charges related to illegal retention of classified documents last Monday, May 20th. That trial date has come and gone, and it doesn't seem like trial will be rescheduled anytime soon. And now the Florida federal judge who Donald Trump appointed is once again ruling in his favor in the case. Judge Aileen Cannon denied a motion by special counsel Jack Smith seeking to prohibit Donald Trump from making inflammatory statements about law enforcement after he pushed the wild and dangerous lie that a standard FBI procedure document included in the Mar-a-Lago search warrant was an assassination plot, even though the search had been planned for a day when Trump was 1,000 miles away in New Jersey. Judge Cannon rejected Jack Smith's motion on procedural grounds and rebuked Smith for not conferring with the defense more thoroughly, writing, quote, The court finds the special counsel's pro forma conferral to be wholly lacking in substance and professional courtesy. Any future non-emergency motion brought in this case shall not be filed absent meaningful, timely, and professional conferral. That's Judge Cannon taking the side of Donald Trump's lawyers who made that argument in their response. But as the Washington Post notes, Smith wrote in a footnote to the motion that prosecutors contacted Trump's lawyers, but his lawyers, quote, do not believe that there is any imminent danger and asked to meet and confer next Monday. Judge Cannon said nothing about the risk of threats and danger to law enforcement officials by Donald Trump's repeated lies. So this is yet another example of Judge Cannon's slow-walking decisions on a growing number of pretrial motions. In a new profile of Judge Cannon, the New York Times describes her as an industrious but inexperienced and often insecure judge whose reluctance to rule decisively even on minor matters has permitted one of the country's most important criminal cases to become bogged down in a logjam of unresolved issues. She has largely accomplished this by granting a serious hearing to almost every issue, no matter how far-fetched that Mr. Trump's lawyers have raised, playing directly into the former president's strategy of delaying the case from reaching trial. Joining us now is Bradley Moss, national security attorney who represents people in the intelligence community, and Andrew Weissmann is back with us. Bradley, I'm going to start with you. When I last spoke with you, I think it was Monday, perhaps, we didn't have any movement from Judge Cannon at all in response to Jack Smith's motion to modify Donald Trump's bond conditions. And then we get this order, which was remarkably insulting to Jack Smith, but that's par for the course, let me be frank, because I've seen Judge Cannon with the government in court. That's exactly what she does. But I tweeted, Bradley, that this is a form over substance issue. She could have set a hearing after doing a very quick briefing schedule on this and addressed the lack of conferral. But didn't Jack Smith actually confer with Donald Trump's lawyers? And they said, we don't think it's an emergency.
Comes back to that phrase that we've been talking about since the beginning of this particular case, judicial discretion, particularly when we're dealing with procedural matters. So, yes, there were certainly alternate options that Judge Cannon could have taken here. She certainly could have set a really quick briefing schedule. She could have also asked Jack Smith's team to submit declarations or multiple declarations from relevant agency officials about the nature of what they viewed as the threat from these statements from Donald Trump. That was a path she could have taken. She chose not to. She didn't do what Donald Trump wanted, which was immediately, order some kind of sanctions evidentiary hearing. But she did basically tell Jack Smith, go back, do at least something to show me you, quote unquote, confer with Donald Trump's team and provide me with something more, put more meat on the bone before you bring this to me in a non-emergency form. Is that within her discretion? Sure, of course it is. Was it a bit of an unforced error by Jack Smith? A little bit. They could have done it a different way. Would other judges have done what she did? Probably not.
Andrew, we have to speak frankly, though, about what I think is not even a double standard here. I mean, to Bradley's point, and I'm very respectful of process, right? There's a procedure that has to be followed. But in this instance, this motion to modify the bond conditions wasn't filed on an emergent basis, but it does allege something that is of serious security and safety for law enforcement officers who executed a duly authorized search warrant that was approved by a magistrate judge and was done in coordination with the United States Secret Service. And so in order to be able to curb what is happening with Trump, is there a fear that there's going to be a First Amendment issue that's going to be raised by Trump's defense?
Well, I can't believe I'm about to say this, but I disagree with Bradley. I think this is something that is absolutely outrageous. I think this is the kind of thing that is going to be, when she ultimately denies when Judge Cannon denies Jack Smith's application when it gets refiled, I think this will be taken up to the 11th Circuit. This is something that the government obviously cares deeply about. Indeed, the Attorney General of the United States talked about how this was a dangerous and false misrepresentation by the former president. Endangering law enforcement is the kind of thing that is the reason that you go into government to try and prevent and to make sure that you are upholding the people's safety, including those in law enforcement who put their lives on the line. For her to have put this off when it was a matter of safety on a ground that is, it's not even a technical ground. There was conferral. And for the defense to say, the defense don't think that's an emergency, that's not the issue. It's the issue is, does the judge think it's an emergency? So I really think this was one where the judge is dead wrong. I think she is making up the procedural issue. I think it is the kind of thing that is going to be used by Jack Smith rightly on appeal. And it shows the same kind of cavalier disregard for law enforcement that caused Judge Cannon to be reversed not once, but twice by the 11th Circuit when this investigation and case was just beginning. And, I think she is really playing with fire here, and she's playing, I think, with people's lives. So I really think this is sort of outrageous conduct by somebody who took an oath of office as a judicial officer.
Bradley, I'm going to give you the chance to respond. I mean, I'm going to outnumber you, I think, right now, because I agree with Andrew. This is a foregone conclusion. We know she's going to say that this motion cannot be well taken by Jack Smith because, like I said, I think she's going to say that there's a First Amendment issue here in terms of the ability to speak. But this definitely is a serious risk to the lives of these law enforcement officers, because remember, Jack Smith's been fighting the disclosure through the discovery process of the identities of many people that have participated in this investigation as well as this prosecution.
Yeah, well, I hope to see when the Justice Department does refile this, when Jack Smith's team comes back with a new motion, I would like to see a lot more substance, not necessarily just the brief. I certainly think they should preempt some of the First Amendment issues. There's been plenty of rulings and analysis on that in the other cases in Manhattan and in D.C. they can use as a foundation. But put some meat on the bone and call Judge Cannon's bluff. She and the Trump team have kind of, been wishy-washy on the idea that there's a threat to public safety, there's a threat to law enforcement. Get agency declarations if needs be. Show her, spell it out to her like she's a 5-year-old if needs be. Here's the threat. Here's every time he's made these remarks and it got amplified in various media outlets. Here's how the threat matrix was increased. Here's the various threats that the agencies received, et cetera, et cetera. Call her bluff on that. It gives you a much better grounds for appeal if she were to deny it on the merits.
Andrew, there's a tipping point, though, to your point, that the 11th Circuit has bench slapped her repeatedly. Is this the one that is the tipping point to be able to either get her off the case or get it reassigned in some way?
It may be, but, this is one where I would say, as somebody who used to be in law enforcement, it's more important that the merits of this be dealt with properly because we are dealing with safety. And if it leads to the secondary goal of the 11th Circuit deciding, you know what, it's the third strike and you're out, so be it. I would note that it really is important to remember that what she did here and her not really giving weight to the allegations of harm to law enforcement is exactly what the 11th Circuit denigrated her decisions about when they reversed her twice, which was her cavalier disregard of the national security of this country. That is at core why she was reversed twice by the conservative panels of the 11th Circuit. So this is, I think, very much of a piece. We'll have to wait and see until see what she does on herself on the motion and what the 11th Circuit does. But I also, by the way, on this, I do agree with Bradley. This does give the government a chance to sort of reset and file things that have more meat on the bones, as Bradley said.